Patrick said, I'm Seth Jaffe. I'm the chief of the Ethics Law and Policy Branch. And you might see this background behind me. It might seem like a computer-generated antiseptic background, but that is actually the office that I am situated in right now. So thank you for attending. I know that there's been a demand for this class. We used to teach this class at the OGE Academy 2 or 3 times a year. Several of you had reached out to us to see if we were going to continue this class in the absence of teaching at the Academy. So we want to make sure that we meet this need, that we support the IG community, and we'll be, as Patrick said, the first half of this class at least will be taped and made available on our website. But we also have an interaction portion of this class in the second half that we will be repeating, hopefully every 6 months, to allow people to be able to continue to attend. Slide 2, please. So, what's the presentation today? We're going to talk about briefly just, who OGE is and how OGE and ethics officials can assist you in your criminal conflict of interest investigations, in your investigations that implicate also the standards of conduct for employees in the executive branch. We can do that by helping you understand the application of these statutes and rules, and also to help you understand what you may or may not need in your investigation to be able to support, the elements of a potential criminal conflict of interest investigation or charge, as well as a potential violation of the standards of conduct. Also, a large part of what I'll be talking about, and I think is very important for you all, are the tools that you can use when doing this type of investigation. In course of running the executive branch ethics program, both at the agencies and at OGE, there are a wide variety of documents that are produced and used in that process that you can use as tools in your investigations. So after 45 minutes to an hour of the first half of the presentation, my colleague Maura Leary will take over the second half after a few-minute break. Well, she'll be talking a little bit more in depth on 18 U.S.C. 208, the primary financial conflict of interest statute, as well as impartiality issues and misuse of position issues and the standards of conduct. And she'll end our class today on the application of those rules and laws in a case study. So a little bit about OGE. We were created in 1978. That might be familiar to you. That was the same year as the IG Act, same year that MSPB and OSC were created. And that was in response to some executive branch scandals that had happened in the 1970s. We currently have approximately 70 employees located here in Washington, D.C., primarily. And we have a presidentially appointed Senate-confirmed director who's also a member of SIGI. Now, we're charged with the overall implementation of the executive branch ethics policy for preventing conflicts of interest. So it's a decentralized program in the sense that we only have 70 employees, but there are 4,000 to 5,000 ethics officials who work in each agency and directly for the agency, who give the training and present the advice to the employees directly at their agencies. Now, as I said, our primary role is the prevention of conflicts of interest. So just think to yourself for a second, what do you think I mean when I say we try to prevent conflicts of interest? So what we want to do is make sure, we at OGE, is make sure that when an employee sits down to do his or her job as a government employee, that they make decisions and perform their job functions only with the public's interest in their mind. And they're not conflicted in trying to pursue their own personal interests or the interests of people or entities with whom they're connected to outside of work. So our job is to prevent the conflict happening as opposed to remedying it after it has already occurred. That could be part of your role as an IG if someone violates a rule or a law, to have either, have an investigation, potentially disciplinary action, potential criminal sanctions. We're trying to prevent that conflict from happening in the first instance. So how do we do that? We have in the ethics program at OGE 4 different primary ways in which we try to prevent employees from having conflicts of interest while they're doing their job. First is that we oversee the financial disclosure system. Now, I've taught this class a lot. I know that many of you are familiar with the financial disclosure forms. There's the public form, the OGE 278, that's publicly available. And there's the confidential form, the OGE 450, which I understand probably many of you on this call fill out. The 278 is only filled out, the public form is only filled out by about 28,000 employees out of over 2 million. And the confidential form is filled out by about 400,000. Now, I understand that probably most of you are familiar with these reports. And hopefully some of you have used these reports in the past as part of investigation. I don't know if one of you would like to share an example of how you have used a financial disclosure report, either a public one or a confidential one now. I know when I teach this class in person, there's always people who raise their hand and say, well, I used it for this purpose, or I used it for that investigation. If there is someone here who'd like to share that, you could raise your hand or put it in the chat, and potentially Patrick could share that, or maybe you could. I do see that we do have a hand up.
Yes, it looks like we have a hand up from Albert. Let me see if we can unmute you. Just a moment. Megan, are you able to help us unmute Albert?
Yes, Albert, you should now be able to unmute and speak.
Well, it doesn't seem to be working at the moment. I see he has the hand raised. I don't see that Albert is unmuting. But if anyone does want to raise in the chat how they've used a financial disclosure form in a conflict of interest investigation, we could potentially share that with the group.
It does look like we have someone in the comments mentions that they used one to resolve a conflict of interest involving stocks owned by a subject in a contracting company. So kind of the classic case.
Yeah, thank you very much for that. And I do know that these are very helpful documents. And we're going to go through in the second part of my presentation today the use of these forms as well as several other forms in your investigations. Now, we also prevent conflicts of interest in addition to overseeing the financial disclosure system by issuing the standards of conduct regulations as they apply to employees in the executive branch. Now, hopefully you're familiar to some extent with the standards of conduct. These are regulations. They're not criminal in nature. But very often when we're consulting with IAGs who call us, the facts of the case do not only lend themselves to potential criminal violations, but they also lead to potential violations of the standards of conduct, because the standards of conduct cover a variety of types of topics: gifts between employees, gifts to superiors, misuse of position, impartiality, outside activities as they relate to teaching, speaking, and writing, outside jobs. So there's a wide variety of topics covered. In fact, we updated the standards of conduct last year in August, but those updates shouldn't really impact your investigations. Now, in addition to the standards and the financial disclosure system, we also issue regulations interpreting the criminal conflict of interest statutes. And those are the statutes at 18 U.S.C. sections 203 to 209. We've issued regulations on 207, 208, and 209. We have a handout that's on our website at the IAG portion of the website dealing with this class that outline the criminal conflict of interest statutes and what subjects they cover, as well as an outline of and a detailing of the topics covered by the standards of conduct. Now, we have a memorandum of understanding with the Department of Justice to interpret the criminal conflict of interest statutes, and that's why we at OGE write regulations interpreting criminal laws. Now, we're expert in the application of these laws, and we're happy to give you advice if you have questions about the application of these laws. But OGE is prevented from determining whether past conduct constitutes a crime. That's reserved for DOJ. In addition, we train and give agency ethics officials, and we issue written legal opinions and other guidance. And those are the ways in which we try to prevent a conflict of interest from happening, trying to ensure that employees, when they're doing their job, only have the public's interest in mind when they make decisions in their job. Now, because we try to prevent conflicts, we don't generally investigate potential violations. We don't prosecute violations. We don't enforce. Those are the jobs of Inspector General, DOJ, and agency management when they want to potentially discipline an employee for violating some of these rules. Slide 3, please. Okay, so, the big picture here is that we know at OGE, without credible enforcement, which we can't do, without credible enforcement by IGs, by DOJ, that our mission is undermined. So we have a very large incentive trying to make sure that these laws are enforced and supporting IGs in that enforcement and investigations. We teach this class regularly, and in a typical year, like last year, we helped investigators and provided technical assistance on approximately 20 different live investigations from over a dozen different OIG offices. And the types of topics that we usually encounter from your offices when you want advice are on things such as financial conflicts of interest, post-government employment issues, financial disclosure requirements, impartiality concerns and misuse of position, gifts questions, gifts from outside sources, or even gifts to superiors. So these are the types of topics that we routinely give you advice on, and we really would like you to, communicate to us about when you want some help with an investigation. So we are an independent agency. We're not part of any other agency, and we think we can give you that kind of independent, objective look at the facts that you may have in a case. Now, that being said, we very much encourage IGs to consult with their agency ethics officials when you have a potential investigation involving an agency employee. And that's because the agency ethics officials have the agency-specific expertise as well as the knowledge of the facts to be able to help you. And they are required to turn over information to you if you are requesting it pursuant to a legitimate investigation, because agency ethics officials, including the attorneys, do not have an attorney-client privilege with the individual to whom they're giving advice. The ethics official's client is the agency and not the individual employee. So if you do need information from an ethics official, then they're required to turn that over pursuant to an appropriate investigation. And we, of course, in turn, always encourage ethics officials at agencies to work and cooperate with IGs. So what about the criminal referral process? What's OGE's involvement in that? So the Ethics in Government Act requires OGE to work with the Attorney General to create a system for reporting allegations of potential violations of the ethics laws. So we have created such a system, and we work with agency ethics officials to make sure that the appropriate referrals are made, and we also work with IGs to make sure that that happens. Slide 4, please. So the way that we've done this, come up with this system, is the OGE Form 202. Hopefully, many of you on the call know what the OGE Form 202 is. This is the form that's statutorily required from the Ethics in Government Act that we've put into place to ensure that when there is a referral for a potential violation of the criminal conflict of interest laws or filing false financial disclosure reports, that is documented and sent to OGE. So there's 3 parts of the form. First is when the initial referral is made to DOJ. Second is when there's a disposition. So if DOJ says they're going to decline prosecuting or they prosecute and there's an outcome, that second part of the form also needs to be sent to DOJ saying what the disposition is. And the third part of the form is if there is a declination and there's no criminal prosecution that happens, there might be disciplinary action taken by the agency. And part 3 of that form is typically filled out by the agency ethics official, letting OGE know if there were any non-criminal sanctions that were undertaken. Now, this Form 202 is on OGE's website. Hopefully you know where that is. If you don't, you can go to our website and see that form. And anytime you make a referral, or a referral is made to DOJ on a violation of these ethics laws and rules, then these Form 202s should be sent to OGE. It's very good for transparency. It's good to see the trends of what's being prosecuted and what isn't. It's also very helpful for training. So please fill these out. In addition, we're involved in the criminal referral process by giving you all technical assistance, by giving technical assistance to ethics officials, because very often ethics officials are unclear whether or not they should be referring something to an IG office. And we also will give them our perspective on that at that time. We typically don't make referrals ourselves. Typically, the referrals are made by the agencies because they have the facts ahead of them, in front of them, to determine whether or not a referral is appropriate. So next, I want to move on and talk about IG's interactions with ethics officials. So first, we believe that it's very important to have open communication with ethics officials and IGs. Some IGs have excellent, relationships with their ethics officials in the agency. Some have less than excellent relationships. In either case, you should have a process worked out to interact with them. Now, one of the handouts that is on our website as part of this class, I really highly recommend that you get this handout and read it. It's an article that was written some years back, entitled in the Journal of Public Inquiry, and it's entitled "Growing Old Together: Inspector General and Ethics Council Changing Environments and Challenges." That article was written by 3 counsels to inspectors general, and it's from their perspective, basically an outline of the best practices for communications and the roles of IGs and ethics officials in OGE. And there are basically a lot of benefits to having this kind of either formal or informal kind of understanding with your ethics office at your agency to have this line of communication. First, as I've mentioned, which we'll go over, there are a lot of documents that are created and used in the running of the ethics program in the executive branch. And a lot of these documents can be used as tools in your investigations. And by having a good open line of communication with your ethics officials, then you'll have an easy access to these documents when you need them. In addition, not only can OGE consult with you on the application and understanding of ethics laws and rules, the ethics officials at the agencies have a level of expertise, and they can also provide you some guidance with the ethics officials, can help facilitate the filling out and fulfilling the statutory obligation to fill out these Form 202s, letting OGE know about the status of investigations into ethics laws or rule violations. And finally, and maybe even most important, having this open line of communication with your ethics officials will help them to not get in your way. There might be things you want ethics officials to track that information on, or investigations or proto-investigations that you want some help on. There might be areas that you do not want ethics officials conducting investigations on that might get in your way. In addition, there might be certain types of referrals that your agency as an IG want to receive, and there might be certain types of referrals that you think are best handled at the agency and that you would prefer not be referred to the IG. And this is the type of information you can share with your ethics officials, to help, facilitate, the most beneficial roles between the two offices. Of course, you're also always free to call OGE to get our technical assistance. But the more effective support that you have and the more effective two-way communication there is between your office and your agency ethics officials, ultimately the better ethical culture there'll be at the agency. Slide 5, please. So I'm going to spend a few minutes just talking a little bit about the criminal conflict of interest laws, the standards of conduct, and then I'm going to go into the second half of this presentation, talking about the ethics documents that are out there, how long they're kept, where they're kept, what should be in them, and how they'll assist you in conducting investigations. So before I go into this, I don't know, Patrick, if there were any questions that we received so far that you wanted to raise from the chat.
There are no questions yet from the chat.
Okay. So the criminal conflict of interest laws. As I said, we're not prosecutors, but we do write the regulations on these criminal conflict of interest laws. There is a summary handout as on our IAG website at OGE that you should refer to see the types of topics that are covered. But very briefly, I'll just mention some of them here. So 18 U.S.C. section 203 to 209, the primary criminal conflict of interest statutes when I refer to them. 18 U.S.C. 203, that prohibits a current government employee from representing a third party back to the government and getting paid to do so. 18 U.S.C. section 205 has similar prohibitions, but also prohibits a government employee from representing a third party back to the government, even if they don't get paid. 18 U.S.C. section 207 is the primary post-government employment conflict of interest statute, and that prohibits former government employees from representing third parties back to the government on a party matter that they worked on or supervised while they were in the government. There are also more executive branch-wide prohibitions for senior and very senior employees from representing third parties back to the government. It's basically the revolving door statute. It provides for cooling off periods for senior and very senior employees. Next, there's 18 U.S.C. section 208. That's the primary financial criminal conflict of interest statute. That's the statute that prohibits an employee from working on a particular matter in which they have a financial interest, or anyone whose financial interest is imputed to them. So an employee can't work on something that's going to affect their own financial interest or the financial interest of people close to them, like their spouse, their minor children, entities with whom they're negotiating for employment. So if they have a financial interest themselves directly, or one of those entities with whom they have a nexus outside of work has a financial interest, that's all treated the same under 18 U.S.C. 208. Next, there's 18 U.S.C. 209. That's the law that prohibits federal government employees in the executive branch from getting paid for doing their government job by someone other than the government. So those are kind of the top level descriptions of the criminal conflict of interest laws. They're in a handout that you can get online. Let me give you an example of an investigation involving one of these criminal laws. A few years back, a FEMA employee was negotiating for a job with the Gallup polling organization. And while they were simultaneously negotiating for this job, they were also negotiating on behalf of FEMA a contract with Gallup in order to have Gallup come in and do a survey of FEMA employees. So they were trying to get a job with FEMA while also negotiating a financial contract between their employer, FEMA, and Gallup. Now, someone actually at Gallup noticed this, didn't think that seemed right, so they mentioned it to higher ups at FEMA. Now, so as a result, because this person was working on a contract with an entity with whom they were negotiating for employment, that was a violation of 18 U.S.C. 208. Now, this person was also a financial disclosure filer, so can you think of another law that this person may have violated? So on the financial disclosure form, they have to report entities with whom they have arrangements for future employment, and that was during that reporting period. So as a result, they did not report that, and they were also convicted of filing a false financial disclosure report. So if you have questions, on these laws, we also have some non-criminal laws that are violations in the Ethics in Government Act concerning outside activities and operations of certain financial and fiduciary organizations. We're happy to consult with you on those. Now, in addition, there's the standards of conduct. Now, the standards of conduct, as I said, are not criminal. These are regulations that put restrictions on employees in the executive branch across a wide range of behavior. And we've issued these standards because the first President Bush, back in 1989, ordered us to and wanted a uniform standard of conduct for employees in the executive branch, which did not exist prior to 1989. So if you're doing an investigation involving the standards, we're happy to help. But the standards cover a much broader range of behavior than do the criminal conflict of interest laws. As I mentioned before, it covers the receipt of gifts from outside sources and also gifts to superiors. Prohibited financial holdings, impartiality, seeking future employment, outside activities, teaching, speaking, and writing, misuse of position. So it really does cover pretty much the whole gambit of potential employee conduct. And what I find happens a lot is that we get calls from IGs who have a fact pattern and they may think it violates a particular criminal law. But very often it might violate a standard of conduct, but it may or may not violate a criminal law. And one example, again, a few years back, there were two EPA attorneys. One EPA attorney was having a family law matter, and they wanted to be represented by the second EPA attorney in their personal family law dispute. So one attorney did represent the other in this personal matter. Partway through this representation, the attorney being represented and had a fee dispute with the other EPA attorney who was representing them, and they reported that to the EPA. So the EPA investigator looked into it and realized that the attorney doing the representing was basically running their private law practice out of their EPA office, using government equipment and doing it on government time. So there were several clear violations of the standards of conduct of misuse of position, misuse of time, misuse of government property. They also didn't get prior approval, which was required at the EPA. But interestingly, there wasn't a clear criminal violation. So because of these standards of conduct violations, the EPA attorney doing the representing was fired, because violations of the standards of conduct can lead to disciplinary action, up to and including removal. So we can definitely help you interpret the facts of your case to determine whether there are potential standards violations. Slide 6, please. So the rest of my presentation, I'll be talking about ethics documents to know. This is really, I think, really important, because these are the tools that you can use during an investigation to try to support whether or not the elements of a criminal conflict of interest statute, or whether there were standards of conduct violations really occurred. This is really how you establish these potential violations. We're going to go through each type of document. We'll talk about what's contained in the documents, where they're kept, how long they're kept, and I'll try to add a little editorialization to try to help you understand just how and when these types of documents will help you. So there's the public financial disclosure reports and confidential ones, which I think many of you are familiar with. Probably less of you are familiar with ethics agreements, the ethics pledge, outside activity prior approval forms, conflict of interest waivers, training files, and advice files and opinion letters. Each type of document here is a little bit niche and applies in very specific situations, but can be vital for you to know whether or not they exist when you're doing an investigation of a particular person. So slide 7, please. So we'll start with the public financial disclosure report. This is an older variation of what the report used to look like. We now have the integrity electronic filing system that OGE put into place about 10 years ago. So it looks like this now, slide 8. Basically, the form just renders differently. Almost every single person who fills out a public form now does so in the integrity system, and this is what it looks like. So presidentially appointed and Senate confirmed employees, PASers, the highest level people, about the top 1,000. That's 1,000 out of many more than 2 million file a public report that not only goes to the agency, but also goes to OGE. So those PAS reports go to the agency and to OGE. They're kept on record for at least 6 years. And typically, if you're doing a review, you would get these reports from the agency. Now, the reason you typically get them from the agency is that there are about 26,000 filers who are not PASers who file public reports, and those are only kept at the agency. OGE never sees them. So if you are doing an investigation of a presidentially appointed Senate confirmed individual, you should still get the report from the agency, but you can get it on OGE's website. Filling out a form, a 201 form, just asking for it. Otherwise, these reports are going to largely, 95% of the time, they're going to be at the agency. And as I said, they're kept for 6 years. There's a lot of interesting information on these forms. Basically, people have to report their assets, their income, their liabilities, to whom they owe money, outside positions, and transactions. They have to update these reports monthly on purchases, sales, and exchanges of certain stocks and bonds. So they're updated every 30 days. Ultimately, you can see how this information can be vital in an investigation. And we had a couple of people at the beginning of this class, indicate how it was important to them in an investigation. So let me give you an example of how this form can be, has been used in an important public corruption investigation. Now, although we're in the executive branch and our OGE in our jurisdiction only applies to the executive branch, members of Congress also fill out the same form. And recently, Senator Robert Menendez was convicted in July last year, actually, on bribery charges. He was found guilty of accepting bribes, including cash and gold bars, to benefit the governments of Egypt and Qatar. So he was convicted on those bribery charges. But let me ask you, do you think he reported the cash and the gold bars on his financial disclosure report? And the answer is he did not. Actually, at the trial, the Senate ethics official testified that the senator had actually received training on how to appropriately report such items. So he was convicted of bribery, but he was also convicted of filing a false financial disclosure report. So it is, often the case that it might be easier to establish a false filing of a report, a false statement, false writing, than it is to establish the underlying offense. But the fact that an individual receives illicit gifts or illicit has illicit income does not, absolve them from being required to report it on a financial disclosure report. Slide 9, please. So here's the confidential report, the OGE 450. You're probably very familiar with this because probably the large majority of you file this report yourself. And so about 400,000 executive branch officials file a 450. Sounds like a lot, and it is. But as I mentioned, there are well over 2 million executive branch employees. So the reality is 80% or more of executive branch employees don't file any kind of financial disclosure report. But it's most likely that if the employee you're investigating files one, it's more likely to be the 450 than the 278. Now, these 450s do not come to OGE. They're filed with the agencies. So if you want to obtain one of these, you'd have to go to the agency. The information contained on these reports is very similar to the information on a 278, but it's less detailed. So there is less information on these reports, but the categories of information that are reported are typically very similar. These forms are retained for 6 years. They are not released to the public. why they're confidential. And in addition, the Stock Act reporting requirements, the transaction reports every month, do not apply to confidential filers. So people, as you're aware probably, who file these reports are not updating them monthly, they're updating them annually. So let me give you an example of where a confidential form was used in a high-profile investigation. So some years ago, an FDA chemist was likely to approve or disapprove an application from a drug company for FDA approval. That's probably about the most financially rewarding information that you could potentially have to know whether a drug is going to be or not be approved. So this employee illicitly traded on this insider information and set up offshore bank accounts, and over the course of many years, made over $1 million in illicit profits based on this insider information. When this came to light, he ultimately was convicted of insider trading. But of course, he did not report in his financial disclosure reports all those years all of that illicit income, which was still required to be reported. So he was convicted of filing a false financial disclosure report, and he ultimately was sentenced to 5 years in prison for making false statements in addition to insider trading. Slide 10, please. So let's talk about ethics agreements. This is a document that you may or may not be familiar with. It's pretty niche, but it can also be vital. So what is an ethics agreement? Typically, ethics agreements are entered into by presidentially appointed and Senate confirmed employees, so the very highest people at your agency, presidentially appointed, Senate confirmed PASers. And it's basically a contractual agreement between the PASer and the incoming PASer and the administration. And basically what it does is it says, throughout my life, I've accumulated conflicts. Basically, people who live a life, they're basically accumulating potential conflicts as they live. They get money, they get contractual obligations, they get friends, spouses, children. These are all good things, but they're potential conflicts for your job. So when a person comes in with an ethics agreement, the goal is to kind of strip away those conflicts. And so it's a contract between the employee and the administration as to identifying the potential conflicts, identifying what they'll do to remedy them, identifying what laws might be violated if they don't remedy them, and then they sign it. So obviously, if you're doing an investigation of someone who has an ethics agreement, you want to know about it. Ethics agreements are typically kept at the agency, but for PASers, which most of them are, who have ethics agreements, it's also on OGE's website. They're kept for at least 6 years. But this is a great roadmap for you, because as I said, it identifies the types of conflicts this person specifically might have. It identifies the laws that might be violated if they don't take remedial action, and then it identifies the remedies. So how does this work? Basically, let's just say you have an incoming Secretary of Energy, and they were the CEO of Exxon, and they have that job, and they also have stock in Exxon. So the ethics agreement needs to be read in conjunction with the financial disclosure report, because the financial disclosure report will say, I'm the CEO of Exxon, I have stock, I have restricted stock units, I have severance, I have this, I have that. So it says they have it, but the ethics agreement says how they're going to remedy those problems. And that's not necessarily in the financial disclosure report. So the ethics agreement might say, well, I was the CEO of Exxon, but I'm resigning. I have stock in Exxon, but I will sell that stock. And then it might say, since I just left working for Exxon under the impartiality regulations, I won't work on something where Exxon is a party for the next year. So that's resignation, divestiture of assets, recusal. And that might all be identified in the ethics agreement. It'll also say what laws might be violated if they don't take those actions. But that's what we really mean about talking about prevention of conflicts of interest. We try to strip away the conflicts before they become real in the person's day-to-day job. Okay, slide 11, please. So we're not going to talk about this very much, the ethics pledge. Now, the last several administrations had an ethics pledge, and these were extra requirements that full-time political appointees committed to when they took their job. And slide 12, please. And this is the most recent pledge that was in effect for the previous administration. But this pledge has been revoked. There's been no new superseding pledge. And we understand that individuals who signed the ethics pledge for the last administration, because it's been revoked, are no longer subject to its post-government employment restrictions. So I think we'll move on because there's no current ethics pledge. Slide 13, please. Okay, outside prior approval forms, outside activity prior approval forms. So many agencies have what are called supplemental agency ethics regulations. And these are regulations that are issued by the agency and OGE jointly. And these are regulations that, based on a particular need of the agency, supplement the restrictions that are already in the standards of conduct. So these are extra restrictions that apply only to either certain or all agency employees based on their need. So you should think to yourself, does my agency have a supplemental agency ethics regulation? Hopefully you know the answer to that question, because it's possible that at your agency, an individual might violate an ethics rule that's in the supplemental, but it's not a rule that any other agency employees are subject to. So hopefully you know whether your agency has a supplemental. Obviously, the ethics officials at the agency can help you interpret that. We can also provide assistance on that. And one of the areas in which agencies who have supplementals often address are prior approval requirements for outside activities. There's no general prior approval requirement for an outside activity across the executive branch. Agencies that want their employees or a subset of their employees to get prior approval, and they want it to be legally enforceable, have to go through the supplemental ethics regulatory process with OGE. And so agencies, about 50, 60 agencies have a supplemental. Many of those agencies who have a supplemental require prior approval for certain outside activities. And so this is an example of a form. Agencies typically have a form for an employee to fill out when it's required. The employee might indicate what their current job is and their current job duties. They would indicate what the outside activity is, when it would be, when they would undertake that activity, and what it consists of. So obviously, if you're investigating someone in an outside activity issue, you first of all want to know, well, were they required to get prior approval? Did they get it? And was the information they put on the form accurate? And again, these are forms that you can get at the agency. They're usually kept for several years. OGE is not going to have a copy of this. This is really just at the agency. If you have a good, line of communication with the agency, then, you certainly can get this pursuant to an investigation. Okay, let's go to slide 14. Conflict of interest waivers. Again, these are similar to ethics agreements in the sense that they're niche. Most employees don't have one, but it's vital for you to know if someone has one of these if you're doing an investigation in a criminal conflict of interest potential violation. So 18 U.S.C. 208, again, that's the statute that says you can't work on something if it's going to directly and particularly affect your own financial interest or the financial interest of someone whose interest is imputed to you, your spouse, minor child, someone with whom you're negotiating for employment. However, there is a provision in the statute that says if an employee has a conflict, that conflict can be waived by the agency if the conflict is not so substantial as to call into question the integrity of the services. So a couple of interesting points here. First, the waiver is issued by the agency. They consult with OGE when practicable. So most of these conflict of interest waivers, they did consult with OGE prior to issuance. Conflict of interest waivers have to be issued prospectively. You can only get a conflict of interest waiver if the conflict has been identified prior to the employee working on the matter that is conflicting. And an employee can only get a waiver if they in fact have a potential criminal conflict of interest. So if you're investigating someone who has a potential conflict, 18 U.S.C. 208, you would want to know whether they actually have a waiver that allows them to do it. Now, the waivers are only for basically potentially small conflicts, right? Not so substantial. And so if it's someone who has a tremendously a large conflict, or it has to do with their spouse's employment, et cetera, it probably won't have been waived. But if you have a situation, for instance, where you have like a DOJ attorney, maybe they own $17,000 in stock in a publicly traded company, and maybe they're involved in a criminal prosecution of someone at that company. Maybe it's a huge company, and the prosecution is not going to threaten the existence of the company. It might be possible that this person would get a waiver to be able to work on that prosecution, even though they own $17,000 of stock in that company. So those are conflict of interest waivers. Obviously, you'd want to know whether or not a subject of your investigation has one of these waivers. Has to be issued prospectively, issued by the agency. They're kept for 6 years. The agency is going to have them. As of August of last year, OGE is posting the names of individuals across the executive branch and the agency where they work on our website, people who got waivers, but not the waivers themselves. So going back 6-7 months and going forward, you'd be able to go to OGE's website to see if someone received a waiver, but to get the waiver itself, this is a record of the agency, and you have to get that from the agency. Slide 15, please. Okay, training files. Training files can be very important. And first, I just want to say that this slide is very representative of all the people for whom I provided training. They've always been that happy to get the training. So all incoming employees have to receive initial ethics training. And certain higher level employees and public financial disclosure filers are required to get annual ethics training. In addition, some of the PASers, presidentially appointed, Senate confirmed, have required ethics briefings in the first 15 or 30 days of their appointments. Now, some of the documents that are produced by training are the fact, sometimes the subject matter that was covered, the date in which the training happened, the attendees. So obviously, these types of files could be helpful to you if you're investigating someone who may be suspected of violating a rule on which they may have recently received training. It's funny, years ago, a former DOJ prosecutor who used to work at OGE told me a story where he said that when he was at DOJ, they were prosecuting a case of a potential violation of 18 U.S.C. 208, and they were in court. And during the trial, they were able to produce a videotaped training that was attended by the defendant in the case. And the defendant was videotaped asking a question on the very issue that was at issue in the trial. Now, you're probably not going to get that lucky, but obviously it's possible that having access to these training files might be able to help you in a particular investigation. These are typically kept for 3 years. And if the training was on potential criminal conduct, it might be kept for 6 years. But again, these documents will be at the agency, not at OGE. Slide 16, please. So before I conclude and talk about advice files, Patrick or Megan, are there any questions or comments, or is there anyone who has a question or comment they'd like to raise now?
Currently seeing any questions, but we can pause for a second, and maybe it'd be easiest to use the chat if anyone has any questions.
So I'll continue. If a question comes in, feel free to let me know.
Okay, absolutely.
So now let's talk about advice files. Advice files can be very important in your investigations. Ethics officials give advice to employees every day. Sometimes they're giving advice 10, 20, 30 times a day. Now, OGE guidance is that it's a best practice for ethics officials to provide ethics advice to employees in writing. I know that IGs have always said, and it is always helpful if the advice is given in writing for your investigations. Now, we advise that ethics officials should do that when practicable. Sometimes ethics officials, like I said, could have 10, 20 questions a day that they're giving advice on. It's not always practicable to give the advice in writing. Of course, with email, a lot of times the advice is in writing. These advice files are kept for 3 years. And again, if advice is given on criminal matters, potential criminal matters, the advice is kept for 6 years. As I mentioned before, these advice files are not subject to attorney-client privilege, even if the ethics official who's giving the advice is an attorney. Again, the client is the agency, not the employee seeking advice. And if you need access to advice files, pursuant to a legitimate investigation, then you'd be entitled to get access to those advice files. So why is this picture on the screen? So this is a picture of 5 people, one of whom at the time was a federal government employee on their golf outing to Scotland. And on the far left, our far left, in the black shirt and white hat, is Jack Abramoff, former disgraced lobbyist Jack Abramoff. To his left and our right is Ralph Reed, former head of the so-called moral majority. To his left and our right is David Safavian, again, the black shirt and white hat. Not sure what it is about black shirts and white hats, but he was the lead contracting official and the chief of staff at GSA. And to his left, our right, all the way to the right in the white shirt is former Congressman Ney. And Jack Abramoff, the lobbyist, spoke with Safavian, the government employee at GSA, and said, I'm offering you a free trip for a golf outing in Scotland. And Safavian was interested in that. So he went to his ethics official. Now, if I were offered something like a big gift like that, I'd probably just turn it down. But going to an ethics official is a good first step to say, well, is this something I can actually take? So he asked his ethics official, is this something I can take? And the ethics official, in an email exchange, told him, well, let me ask you a question. Is the person offering you the gift someone with whom you have a close personal relationship that would justify the giving and the accepting of the gift? And Safavian said, yes. And the ethics official also asked via email, is the person who's offering you the gift doing business with or seeking to do business with GSA? And Safavian said, no. Those answers are what are colloquially known as lies. So it turns out that Mr. Abramoff did not have a close personal relationship with Mr. Safavian. He was a lobbyist, and that's how he knew him. And in addition, his organization that he represented was simultaneously, offering this gift and trying to negotiate a lease agreement of GSA property on favorable terms. So when this came out, there was a congressional investigation, there was an IG investigation, and Mr. Safavian, continued to stick to his story that it was a personal gift and that Abramoff's organization was not seeking or doing business with GSA. Since those were demonstrably false claims, he ultimately was convicted of obstructing an IG investigation and making false statements. But what do you think was some of the evidence that was used at the trial and admitted? It was the advice files. It was the emails back and forth that he had been asked these questions in real time. He had given the answers to the ethics official that ultimately were demonstrably not true, and the advice files were integral in the trial. So having access to these advice files, as well as having access to these other ethics documents that are largely kept at the agency, sometimes on OGE's website, can certainly help you in these investigations. So at this point, that's all I have. But before we go to a break, I'd like to know if anyone has any questions. I do know that when I teach this class with like 35 attendees live, it's much more interactive with dozens of questions. I think with 400 attendees, it doesn't necessarily lend itself to easily answering or submitting questions. But if you have a question, I'll give people a little bit of time here.
Yes, and actually we do have a question about the current topic of advice files, which is, are there retention requirements for keeping those files?
Yeah, so typically speaking, advice files should be kept for 3 years. If advice is given on a criminal conflict of interest issue, they should be kept for 6 years. And one other thing I'll mention is that what's often included in advice files are opinion letters. Now, I think DoD requires it, other agencies provide outgoing employees an opinion letter on their post-government employment restrictions on 18 U.S.C. Section 207. And if you're investigating someone who is a former employee and it's a potential violation of that statute, you might find an opinion letter that was provided to them in their advice file, because very often it helps the employee to know what the limitations are, but it's also very much wanted by their potential future employer because they want to know what they're accused out of and what they can't do. So if you're investigating a former employee, you might want to check the advice files for opinion letters on their post-government employment opinions provided to them on their way out.
Great, thank you. Seeing any other questions, and as a reminder, hopefully we'll have a few minutes at the end of today's presentation for questions, so people can keep thinking about those. Shall we go ahead and take a quick break?